A person who was entering the property said that there's potential public order offences that have been reported. Therefore, I can require your details so that that can be investigated. I'd like to do that rather than arrest you so that...
The interaction begins with an officer immediately asserting authority by claiming there are potential public order offences reported by someone entering a property and using that claim to demand personal details. From the outset, the officer frames the encounter as compulsory rather than voluntary, presenting the auditor with a false choice between providing details or being arrested. This is significant because under UK law, police cannot demand name and address simply because an allegation has been made. There must be reasonable suspicion that an actual offence has occurred, not merely that one could have occurred. By relying on vague language such as potential offences, the officer lowers the legal threshold in a way that is incompatible with due process and sets the tone for a coercive encounter rather than a lawful investigation.
Sales, or I can arrest you.
Yeah.
So that...
What's the details? Can I have your name and address? Name and number, officer.
Can you grab my phone so that I can...
You've just seen us outside the police station.
Can you identify yourself,
right,
please?
Can I explain why I've stopped you?
No. Answer my colleague's questions. Thank you.
Identify yourself, please.
A person who was entering the property said that there's potential public order offences that have been reported. Therefore, I can require your details so that that can be investigated. I'd like to do that rather than arrest you so that we can deal with it now. So let me just confirm.
Can you identify yourself, please?
You've not done that so far. Are you a constable or are you in prison?
I am.
That constitutes an offence.
11733.
Sorry?
As the situation develops, the officer repeatedly pressures the auditor to identify himself, despite failing to explain clearly what offence is being investigated. The demand for identification is repeated several times, accompanied by escalating insistence rather than clarification. This reveals a common policing error, assuming compliance can be achieved through persistence alone. The auditor's refusal is calm and lawful, highlighting that in England and Wales there is no general requirement to provide identification unless specific statutory conditions are met. The officer's inability to articulate those conditions exposes a fundamental misunderstanding of police powers and transforms what should be a consensual encounter into an unlawful attempt at compulsion.
73. On police. Can you offer me a number? Thank you. Thank you. So at the moment I'm going to talk to this officer here because he's the one who's approached us at the moment.
Possible public order offence.
For what?
I'm just trying to...
Gate? No, I don't think so.
No, just due to an interaction you had with them. That's the report I've got from them.
What interaction?
You also get to report and tell me what you want. So
we don't want to say nothing, thank you.
There you go. If you don't want to say anything,
comment.
But they did want to say something. So,
well,
unfortunately, when a crime is reported, that gives me powers to A, stop and detain you, to deal with that crime, and if required, arrest you.
Yeah.
My colleague now is just taking those details.
That's a load of crap, I think.
So once I know more about the report, I'll be able to tell you more. However, until then, I'm going to take some details.
No, thank you. Not until we know more details, at least.
You've been threatening people, you've been intimidating people to come in.
The officer claims that because someone has made a report, he now has the power to stop and detain the auditor to deal with that crime. This is a critical moment because no such general power exists. Police may investigate allegations, but they do not gain an automatic power of detention simply because a third party has complained. Detention on the street requires either lawful arrest or the use of a specific stop-and-search power grounded in statute. By inventing a power to detain for questioning, the officer demonstrates a serious misunderstanding of the limits of his authority and risks unlawfully depriving the auditor of his liberty.
That's a lie.
Well,
they don't want to, they didn't ask for it.
Are you the feeling police then, are you?
The feelings police?
The feeling, yeah, because they feel intimidated, you have to deal with it.
People feel intimidated and threatened by it, and they don't like it.
Well, that's their problem, not mine.
If some people intimidated you, you want us to investigate,
No,
wouldn't you?
no, because I've already been through that one, and they didn't do anything about it. Right,
That's
so
you. But other people, if they feel
no,
threatened
the
or
police didn't do
intimidated,
anything about it.
they'd want us to speak to them on that.
Because
That's
it's the
what we're doing.
police, you're doing something about it. And we haven't committed a crime. There's no law against us filming.
No,
outside.
no, I'm not saying there's a law against you filming.
So we haven't committed any crime.
I don't mind you filming, crack on.
and we're filming from a distance, and there's evidence of that on my camera, his camera,
their
and
feelings
cameras
don't come
like
into
that.
it. Their feelings don't come into it.
Why not?
Because they're police. You have
says they're
a
police?
higher tolerance.
Who says they're police?
The control staff, whatever.
Who says they're
They
police?
work.
A second officer enters the interaction and attempts to justify police involvement by claiming that people felt intimidated by the filming. This marks a shift from alleged conduct to subjective emotional responses. Feeling intimidated, however, is not itself a criminal offence. For a public order offence to exist under Section 5 of the Public Order Act, there must be threatening, abusive, or insulting words or behaviour that would cause harassment, alarm, or distress to a reasonable person. Simply filming from a public place does not meet this threshold, regardless of how uncomfortable it may make others feel. The officers begin policing emotions rather than enforcing law, which is a dangerous and unlawful precedent.
Control staff or the police. Some of them were police. Some of them were police
How do you know?
because they showed their ID badge.
There might have been a police case.
Yeah.
There could be a civilian member of staff.
Well,
You don't have frontline.
they still have a high tolerance of
How do you know that?
because I do. You
Because
have
we do.
if I swear, if I keep swearing and swearing, you can't do me for it because you have a higher tolerance.
Yes, we can.
Yes, we can.
Under Section 5 of the Public Order Act,
You have a higher tolerance
can.
if I'm swearing to you than I was
You don't
swearing
know
to
who
public.
you're talking to there, do you?
Okay.
I wasn't talking to nobody.
You don't know who they are.
I'm talking to nobody.
You're putting the cameras in front of their faces. You don't know who they are.
That's a
The
total lie.
lady spoke to me, so in interaction I filmed it, which I'm not allowed to do.
Yeah.
So there is no crime here whatsoever.
If they're intimidated by it, they will-
okay, but under
Yes,
Section 19 of the Police and Criminal Evidence Act, when a crime is reported,
The discussion around intimidation reveals another legal flaw when officers suggest that police staff or officers are entitled to special protection from being filmed. In reality, police officers are expected to tolerate a higher level of scrutiny and criticism than members of the public. This principle, often referred to in case law and Crown Prosecution Service guidance, recognizes that public officials must accept accountability. The auditor correctly points out that filming in public is lawful and that feelings, whether of officers or civilians, do not override established legal rights. The officer's inability to counter this with lawful authority underscores their weak legal footing.
and seize any articles that may provide evidence of an offence.
And then I'll sue you.
So,
And me.
as I'm saying, you're saying you've recorded it, therefore that almost makes, I can 100% guarantee there's evidence on those machines.
But we didn't do anything.
Okay, so let us just have a chat.
Exactly.
Let's see what's going to happen. Okay, and we'll get to the bottom of it. We're not being argumentative with you.
You are,
We're
'cause
telling
you're trying to,
we were trying to leave. I
we
didn't have an
told-
issue.
We
Hang
were
on.
trying to leave and you
Hang
stopped
on,
us.
and I didn't have an issue.
Exactly.
However, prior
That's
to
the
me
issue.
leaving,
My issue.
someone reported and told us via the radio that they said that you were aggressive towards them.
Rubbish. That's lie.
Hang on,
Go and tell them the lie and
Does
do
it-
them for lying to the police.
hang
then.
on, hang
You
on.
felt intimidated, all right?
No, they said we.
Sorry,
see.
intimidated, aggressive and intimidated. Okay.
Well, wasn't
However,
aggressive,
listen,
that's a lie.
Listen,
And
you're
you got-
interrupting me now.
The encounter reaches a critical escalation when an officer attempts to invoke Section 19 of the Police and Criminal Evidence Act to justify seizing the auditor's phone. This is a profound legal error. Section 19 applies only when an officer is lawfully on premises and allows the seizure of items that may be evidence of an offence. It does not apply to people standing on a public street, nor does it grant a power to seize personal property during a street encounter. The officer's misapplication of this power reveals either lack of training or a reckless disregard for legal boundaries, as unlawfully seizing the phone could amount to an interference with property rights.
Get to come and ask you and say that's what's been said. You get your chance to tell me.
Well, that's a lie.
Okay.
We
Nasty
didn't
character,
do.
mate. Him.
That's a lie.
But when a criminal offence is being alleged, and one has, we are entitled to do that.
Look at that ugly face he's got. Do you feel offended by that? You shouldn't do. Just let them get on with what they've got to do.
So why didn't you stop outside the gate instead of stopping there?
That'd be more
Because we
appropriate.
didn't get told until we got there. But thank you very much for.
I bet that's a bit of a porky pie. Literally porky.
So can I report a crime?
If it's genuine,
Yeah.
If it's genuine.
I feel intimidated. And, you know, I feel that you're being aggressive, so I'd like to report that.
okay.
That's not reporting a crime, that's reporting a complaint.
That's a crime. You just said it was a crime.
The officer further compounds the error by arguing that because the auditor has recorded the interaction, the footage must contain evidence and therefore justifies seizure. This reverses the burden of proof. In UK law, it is the responsibility of the police to establish reasonable grounds that an offence has occurred, not the responsibility of the citizen to surrender property to prove innocence. The officer's reasoning amounts to a fishing expedition, seeking evidence first and justification later. The auditor's refusal to hand over the phone is both lawful and strategically sound, preventing an unlawful intrusion into his privacy.
You saw us down in outside the station when we was out there, but you didn't want to stop us because it's raining. You got in your little car, you left, let us do what we wanted to do, go home, or go at the next location, and you got in your car, and you thought you'd be cliffing that to waste our time, but it ain't really waste our time, is it?
I appreciate your opinion.
That's my opinion.
As the officers continue, they rely heavily on an unverified third-party report alleging aggression or intimidation. However, the auditor's demeanor throughout the interaction is calm, measured, and non-confrontational. Police are required to assess situations objectively, not blindly accept allegations at face value. The visible mismatch between the accusation and the auditor's conduct severely undermines the credibility of the alleged offense. The officer's insistence on treating the allegation as fact rather than hypothesis demonstrates confirmation bias and poor investigative practice.
Okay, again, so as I said, and typically it's now going to get noisier.
Yeah,
As I said, a crime was alleged. I'm going to ask you again, will you provide me with your details? I'll apologise, I couldn't hear your answer due to the loudness of that machine.
No problem. Yeah, no thank you.
You said no? I still can't hear you.
No,
No, thank you.
because we haven't committed a crime.
Exactly.
Well, unfortunately, you're entitled to your opinion, but when one is alleged, I'm entitled to mine.
At one point, an officer suggests that the auditor himself is being aggressive simply by refusing to comply. This is a common but improper tactic used to pressure compliance. Exercising legal rights, refusing to answer questions, and filming police activity are not acts of aggression. They are lawful forms of civil resistance. The auditor's calm persistence deprives the officer of any legitimate basis to claim a breach of the peace, which requires an imminent threat of violence. The attempt to redefine non-compliance as aggression is a form of procedural gaslighting.
So the police station is over there. Right, and we left there. We was walking by. Now this car's just approached us. It's obviously a police vehicle, and it's the armed police outside Cold Harbour
I think I've met before somewhere else.
police station.
On another occasion, and they've got intentions to go to another location after this.
Yeah, I'm going back home. The next
yeah,
location for me, bed.
Okay, there'll be a report made and we've got your descriptions, okay?
And
Lovely.
We've done is on camera as well.
You
so-
felt you'd done some work today for the public. Got my description, our descriptions. No one's offended that police station.
Enjoy your days.
Enjoy your day.
You too.
Thank you very much for the fish, not crime in public. I'll make sure they remember that in a minute. Get their fucking numplate after that business. How dare they even chase, right.
The encounter concludes with the officers disengaging after failing to obtain details, seize equipment, or identify a specific offence. As they leave, the auditor responsibly records the police vehicle details, preserving evidence for a potential professional standards complaint. This final moment encapsulates the importance of auditing. The officers misapplied legal powers, attempted to enforce feelings over law, and demonstrated poor understanding of seizure authority. The outcome reinforces a key lesson: knowledge of the law, calm demeanour, and refusal to be coerced are powerful tools.